Welcome to Immigration Uncovered, the docket-wise video podcast where we dive deep into the fascinating world of immigration law. I'm James Pittman. This is episode 38, and I'm here with Rekha Sharma-Crawford. Rekha is the current treasurer of AILA, the American Immigration Lawyers Association. She is a co-founder and partner at Sharma-Crawford Attorneys at Law. Rekha, welcome, and thanks for joining us.
Thank you so much. I appreciate being invited.
Well, we're going to talk today about the topic of ineffective assistance of counsel in the immigration context. And it's a subject that Rekha has been doing a tremendous amount of work on. So she is really at the forefront of trying to create change for the requirements for IAC claims. And we're going to get right into it. So Rekha, first of all, let's talk a little bit about the concept of ineffective assistance of counsel in the context of immigration law. What is it? When does it arise?
Ineffective assistance of counsel is the same in any area of law, right? And it's what they looks at is whether an attorney's conduct has been deficient in some way, and that has then resulted in someone being harmed.
Okay. So what are some examples of ineffective assistance of counsel that arise in immigration cases?
So you may have things such as where an attorney fails to properly assess a case for all forms of relief. You may have a case where, there was either cultural or other societal norms that an attorney didn't take into consideration, didn't present to immigration to provide context and nuance about a case. It may be a missed deadline. So it can vary in terms of what it looks like, whether it's in immigration court, whether it's not in immigration court. It could be affirmatively before USCIS. And so, errors on a form that were inadvertent. For example, an easy one is that, in other cultures and other parts of the world, the date is put differently, right? We put month, date, and year. Other places put it date, month, and year. But it can have a profound impact in terms of creating a discrepancy in the application itself. It's an error, but it is a form of ineffective assistance of counsel.
Okay, and we're going to get into talking about the immigration court context in a minute, because that's where we get into our Lozada motions. But if you're pursuing a claim of ineffective assistance of counsel and it's outside of immigration court, how exactly is that going to be different in terms of the process?
So most commonly, ineffective assistance of counsel is a term of criminal art, right? So what I mean by that is it is a term that is born out of the criminal courts. In civil proceedings, it's usually called malpractice. It's not called ineffective assistance of counsel or ineffective assistance of counsel. So in reality, what's happened is in the immigration context, we use the nomenclature from criminal court, but then we pile on other requirements that aren't found in criminal court. But one thing I do want to bring up, which is that Lozada motions can appear, you said, only in the context of immigration court. That's not necessarily true, because even the USCIS side of the equation will require the filing of a Lozada disciplinary action, and to meet the criteria of Lozada, even when before an affirmative form of relief is requested and the claim being raised is ineffective assistance of counsel.
Okay. So now, how does ineffective assistance of counsel impact the outcomes of immigration cases for individuals? Just give us some examples. Now, obviously, if you're in immigration court, it could result in a removal order. What are some other examples?
If you're before USCIS, it can result in a denied application. It could result in a missed deadline. It can result in a missed RFE response. It can have some huge consequences, and especially when you're dealing with backlogs, where you're dealing with priority categories, where you're dealing with deadlines, appeal deadlines in immigration court before the circuit court deadlines. Like, it can come up in a variety of ways. But again, I think it's the concept is very uniform across all practice areas. It's just applied very differently in the immigration context.
Okay, so the way that I've personally seen ineffective assistance of counsel mostly has been, back when I was practicing in immigration court, we talked about a Lozada motion. A Lozada motion was what you filed when, a client came to you and they had a removal order and you want to go back and reopen proceedings, and because you've discovered that the prior attorney, didn't do certain things or failed to do certain things, that resulted in the client's case, not being, properly put forward, and they got a removal order. So let's talk about that. What is the Lozada framework? I'll give the question to you, and why was it established?
So this is kind of a little bit in the weeds, but I think it's important for people to understand, especially those people who don't practice in immigration law, because when you talk about ineffective assistance of counsel to people who don't practice immigration law, they're pretty astonished by the Lozada requirements. Now, there are certain things that are common across disciplines. So, for example, the idea that you have to establish that there was an attorney-client relationship, pretty common in a variety of disciplines. That you have to establish that the prior counsel's conduct was deficient and did not rise to what a normal, reasonable attorney in that situation would do. Again, very common across disciplines. But then here's where it gets weird, which is that in the immigration context, what you have to show is that you filed a bar complaint with the disciplinary advisor, provided an opportunity for the attorney who was facing the disciplinary action to be able to respond to that complaint, and then include all of that with your motion before the immigration court or before USCIS, and then, of course, show that there was harm, there was prejudice. So the 3 of the 4 criteria are pretty common across legal disciplines, but this requirement, this mandatory compulsory requirement of having to file this disciplinary action with the disciplinary advisor and the ethics committee, with the state bar basically, is so unique that it really is the only, immigration practice is the only area of law that is bootstrapped with such a requirement.
So just to highlight this, so let's say if you're doing criminal defense and someone gets, convicted, they go to a subsequent attorney and say, hey, my attorney screwed up, I got convicted of the crime. You go back to let's say the state, criminal court, and you could try to reopen the case claiming ineffective assistance of counsel, but you would not need a bar complaint. But is everything else that we've talked about with Lozada would pretty much be the same?
Right. You mean you would basically present to the court, look, here are the facts, here's where the conduct was deficient. And then, the court would look at the record, hear the evidence, and make a determination, was there prejudice? Was there harm here? And if there was, justice steps in as it should, and it allows for the opportunity to cure that error. So that's exactly right. You don't have to file a bar complaint because the criminal court, is empowered to be able to dole out that justice as the facts determine.
Now, so in the immigration context, it's the BIA, the Board of Immigration Appeals, that came up with this framework and imposed this requirement of filing a bar complaint.
Yeah.
How long ago was it? That's been around for quite a while, and has it ever been challenged before?
So 35 years.
Right.
So it's been around for decades. And this is one of the things that I think is so critical to understand is that generation after generation of immigration attorneys have been taught that this is normal.
Right.
And, when people who don't start in immigration, like I did, I didn't start out in immigration. When I first entered the field, I was like, what is this? And how is this normal? And how are people not just completely befuddled by what is happening here? Like, this is not normal. But what I like to say is it is not normal to file bar complaints. That is not a normal thing, right? Yes, the legal system and lawyers are empowered to self-police, and we should. And where there is, people who are acting in an unethical or improper way, they're still subjected to the bar complaint requirements, and that this effort doesn't change that in any way. But the normalization of filing bar complaints just to seek justice, that's abnormal. That's not normal.
Has it been challenged any of the circuits? I seem to recall having seen that some of the federal circuits were making exceptions to the Lozada requirement.
So yes, it has been challenged. And what I can tell you is that every circuit has found that substantial compliance with Lozada is required, okay? But with regard specifically to the bar complaint requirement, what the courts have said, and there are some jurisdictions that have held, that it is not, where the record is clear, that it is not a determinative factor that you don't file the bar complaint, but you still must explain why you didn't. And part of the issue is, prior to Loper Bright coming down, Chevron deference was a very critical piece of the analysis in Lozada. So even the federal courts were deferring to the Board of Immigration Appeals to say, Chevron deference says that we will let the agency make these determinations and we will defer to the agency. So what you see right now is you have the patchwork of courts in the circuit arena that some allow for it, some don't allow for it, some are strict compliance jurisdictions, and they don't allow for any wavering of filing of the bar complaint requirement. Now, what's really fascinating is that it really is, when you start to kind of look at the history of Lozada and also the practical side of how Lozada works, what you see is that the immigration courts never wait for a decision from the disciplinary advisor. So again, if we're going to force you to file it, but we're not going to wait for the outcome, then what mechanism does it serve?
What's the import of their decision then if the immigration judges are waiting for it? Exactly.
Exactly. And so when you delve into the history of Lozada, part of where you get the most amount of information is you get some dissenting opinions. They start with Lozada, Rivera, and you really get people who are behind the curtain, so to speak, at the board saying, look, this doesn't make any sense because you are forcing people to do it. And it was board member or chairman Paul Schmidt who basically said, look, I don't need a bar complaint to tell me how to look at the record. Right, because if you're going to be anointed as an adjudicator, as someone who's empowered to make decisions, then make them, right?
It's also strange from the vantage point of filing a bar complaint is a mechanism for someone to seek redress of being wronged by an attorney, but it's something that can be exercised or not exercised at the discretion of the aggrieved party. So I'm trying to think of, as you're talking, I'm trying to think of whether I can think of any other examples where a court is requiring you to avail yourself of a grievance mechanism in order to actually adjudicate what is otherwise a completely legitimate, factual issue.
There are no other areas. In fact, there isn't. And you look at it from traffic court to the U.S. Supreme Court, there are no other areas that require this. That's what makes it such an anomaly, right? But 35 years of indoctrinating attorneys to say this is normal, this is what we should be doing, has had such a profound impact on the practice. And I would say not a good one.
Right. It really has. And and certainly when I got into the field, it was already something that had been around for a long time. It's just something you sort of learn. If, becomes second nature, there's a Lozada motion. If you handle removal cases, be careful, because if the client gets a removal order, the next attorney could file a Lozada motion. It's just something that you learn to, that is out there. But let me ask you this question. What did the board think that it was trying to accomplish by making that requirement?
Now, this is a little dicey because I will tell you what my interpretation of what the board did is. Of course, I can't speak for the board, nor would I ever try. But what I can tell you is that when you look at matter of Rivera, which is a subsequent case to Lozada, right? So before I go there, prior to Lozada, the Strickland standard was also applied in immigration proceedings. So you get to, prior to Lozada, matter of Garcia, all of these cases exist that say same kind of thing, deficient behavior and then prejudice, right? And which is consistent with the Supreme Court decision in Strickland v. Washington. A criminal standard, terminology is criminal, ineffective assistance of counsel is a criminal concept. So yeah, all of that seemed very logical. You get to Lozada, they implement this procedure, and you really start to understand why the board goes here when you look at matter of Rivera. And what you find is they use the word collusion about 13 times, right? And so what they're concerned about is that really what they're telling you is that immigration attorneys, unlike every other attorney out there, is somehow going to violate their own oath and their own, due diligence and their own character and their own ethics to collude with their clients to try and somehow game the system. And quite honestly, I find that to be incredibly offensive, right? Because I don't think that most immigration attorneys are like that. I think when you look at how it then plays out, it almost feels, I would say, punitive to say we're going to try and punish immigration attorneys because we know certain things. We know that those individuals who are represented by counsel in the immigration process fare better. So it's almost this deep-seated, way to kind of punish not only the attorneys. In my opinion, it's also to punish those non-citizens who are going through the process. And it just feels that way when you go back. Now, again, let me be clear. That is my interpretation. I'm not speaking for the board. I cannot say that is exactly what they were doing. But when you use the term collusion that many times, I can't think that isn't a compliment.
Right. And you wonder, it just begs the question of if that is in fact what they were thinking, was there any data upon which they, could base such a line of reasoning? Or is it just something purely anecdotal, like they saw maybe one example of that, or, and all of a sudden that loomed so large? It just makes me wonder, why do they think that collusion would occur? I mean, what are they basing that on? But anyway, we don't have the answer to that question, but it is a question that just jumps out at you as you're explaining your interpretation.
Well, and I mean, I think the other piece of it is again, we're talking about 3 decades of history. So let's assume that, there was something that they were looking at. The problem now is it is so baked into the system that they've never went back and looked at it to say, wait, have we cured the problem? What was going on? Have we solved the problem? It's so baked in now and normalized that there's never been any case that has now gone back and said, hey, we want to look at what the dissent was saying in Rivera and in Lozada. And they predicted it. That's the beauty of it. In Lozada and Rivera, the dissent predicts this. It says, we think this is going to have a profoundly negative impact on the practice. So with that out there, right, even assuming, and let's assume good intent, even assuming that the board at the time had good intent and they were actually trying to cure something that was going on, you would think in over 3 decades, that they would have then gone back and re-looked at it.
I mean, first of all, ineffective assistance of counsel is something which, while not, very common, is certainly something which is not exactly very rare. It is a problem which is somewhat significant, right? So you would think that if they actually were targeting what they thought was the root of the problem, that it would beg revisiting at some point. And clearly that hasn't happened. Which just brings us to, where we are in things now. But before we get to that, let's talk about just a little bit to some more context. Why do many practitioners and clients find specifically the bar complaint requirement problematic?
It's a barrier to representation. It really is. Immigration attorneys, are fearful. I mean, you look at how many parameters could possibly come up. I mean, you look at right now what's going on in immigration courts with matter of Fernandez and Nish Chavez and all of these permutations, right? And it's like, well, if I didn't make an argument, was I ineffective? And if I did make an argument and the board later makes a different decision, I mean, for most attorneys across disciplines, they will tell you dealing with the disciplinary advisor is terrifying. I mean, it's the one thing in law school they really kind of hammer into your mind to say, do things correctly, because you don't want that call from the bar saying, hey, we have a bar complaint against you. So you have attorneys who refuse to take removal cases, even though we know that those people who had representation in removal proceedings fare better, even though we know that immigration is, as a discipline, only second to the tax code. And so the complexity of it is there. But you are having individuals who say, I don't want to practice this because I don't want the stress of this. And so then you have those kinds of issues that go on. On the flip side, you have non-citizens who come from places, not everyone, but a large majority of them come from places where, authority and how authority is seen is questionable, right? And so there's this inherent fear of, if I'm going to file a bar complaint, whether it's against my prior lawyer or whatever, what kind of retaliation do I face? What kind of retribution do I face? And so you have people who walk away from relief or walk away from, things that they may be entitled to because they too are scared to do it. So it's kind of a pressure situation. You have attorneys that are not willing to take the cases. You have clients who are too scared to raise the claims. And so you have this barrier that gets created. That's a lose-lose proposition for the system.
It's like a vicious circle there, or a loop that's created where you've got, the respondents who are, maybe or typically are quite unfamiliar with the legal system. They already feel like they're in trouble because they were in removal proceedings. Now that you're asking them to get further entangled, in legal proceedings by filing a bar complaint, and they're unfamiliar with that process and unfamiliar with attorney ethics and probably very inhibited from doing that. And then you've got the attorneys, right, who don't want to, first of all, they don't want to besmirch or attack a colleague, and they don't want anyone turning around and attacking them if they should lose a case. If they should do their best and lose a case, they don't want to be accused of not doing their best. So it's a vicious circle. Wouldn't you agree?
I mean, I think that's right. And I think there's also a slightly nuanced issue that has come about. Again, I think they predicted it in the dissents that were coming. And that is that, think about, when we go into criminal proceedings, it's the defendant versus the government, right? And there is a power differential because the government holds all the cards. And they're willing to kind of look at the situation and say, okay, what does justice require? And they feel empowered to be able to do that in most instances, right? Here, you pit one immigration attorney against another immigration attorney. And so it creates a very, it creates an environment in the practice that sometimes is uncivil.
Yeah.
Right?
It's like vituperative, I guess would be a good word.
Yeah.
Are there any ethical and professional concerns for the attorney that would have to file the complaint? Let's say you do a lot of removal proceedings. Let's say removal is everything you do. And you deal in communities where you see a lot of people getting removal orders, and you find yourself in this position of trying to reopen cases maybe several times per year. Are there any concerns that an attorney in that situation would have to have that you can think of?
It's interesting because the ethics codes across the nation say that an attorney should not file. It's unethical for an attorney to file a frivolous bar complaint.
It's understandable.
Right? Okay. But if I can only access the courts by having to file a complaint, then arguably I am now having to violate my own ethics code in order to comply with what the board requires me to do. That's also a very weird kind of a situation, because if I know that, attorney A had made a mistake, or an attorney is willing to say, I made a mistake, right? A mistake is not necessarily an ethical violation, right? And so now I have to say, and this is the thing, right? In criminal court, people do it all the time, criminal defense attorneys will come in and say, especially where you're dealing with immigration types of issues, where they will go in and say, you know what? I didn't really understand that a plea to marijuana was going to get my guy removed. We didn't know, right? And then the prosecution will come in, and the defense attorney will sit down and go, look, we want our debt to society. We want to be able to hold them criminally liable. But by the same token, none of us want this guy to be deported. So, I mean, it is kind of this thing where, you know, in order to comply with Lozada's requirement, you can't self-report and say, well, you know, the attorney said that they made a mistake and I'm attaching an affidavit to the motion. Board has said that's not good enough.
Yeah, but I mean, it does. I just want to counter just a little bit in that it does. Yeah, certainly unethical to file frivolous bar complaints against colleagues for sure. But it does place the onus on. Now, again, it's putting them in a position where they're feeling compelled to do that in order to avail themselves of the Lozada framework. But it does put the attorney in a position where they have to really exercise judgment as to whether is there really a good faith argument that prior counsel was ineffective and breached a standard of care, if you will. Or, you know, is the claim that I'm making, if I'm only making it to comply with Lozada, but there's really nothing there that truly rises to the level of ineffective assistance of counsel or violation of ethics or a negligent mistake, you know, you shouldn't bring it. I agree. It's definitely by far to say suboptimal is putting it mildly. It's a very problematic framework to impose that requirement. But, you know, attorneys who are trying to get cases reopened for ineffective assistance of counsel, I mean, they need to exercise good discretion.
No, that's true. And you know, like I've always said, this effort does not in any way take away from a bad actor doing bad things. They're always going to be held accountable, right? That is a proper use of the bar complaint requirement. It's why it exists. Every disciplinary advisor out there will tell you that that is why it exists. But I think that the problem happens is that if you have somebody, let's say that I've had to do that before where I've self-reported. It was a miscommunication, an absolute miscommunication between me and the government's counsel, right? I had the email to show it was a miscommunication. That's all it was. In any other area of law, a judge would have said, clearly the evidence is there. We understand it was a miscommunication. It wasn't anything else. There's not an ethical violation. It's just a miscommunication. The judge said, no, I'm not going to allow for it. Government stood mute. And I will tell you, I self-reported to the bar and I said, I have to report myself. And they said, but you didn't do anything wrong. I said, I understand, but I don't have a way to get back into court.
My goodness. Let's highlight this because this is going to seem so far-fetched to people who don't practice removal defense. There was a good faith mistake in communication.
Yeah.
Between you and the DHS attorney, and you brought that to the attention of the court, and the court not sua sponte reopen.
No.
So you actually had to file a bar complaint naming yourself.
Yeah. Because that was the only way I could protect the client, right? And I literally said, I don't have another but see, that's my thing. Is that a frivolous bar complaint? I think it is. I think it is absolutely a frivolous bar complaint. But here I was in the situation, and I said, well, I'm not going to let anybody else file a frivolous bar complaint, so I'll just self-report. And I kid you not, that was the only way I could. And I'll give you the situation. It was a situation where the client had to go get their fingerprints taken. And there was an agreement. There was, these disconnects that sometimes occur between how USCIS is going to fingerprint somebody in removal proceedings and how do you get them to get fingerprinted and whatnot. I had an entire email chain with government's counsel that said, we need to get fingerprints taken, and me saying, can we please get them fingerprinted? Can we please get them fingerprinted? We walk into court. Fingerprints aren't done because we don't have a way to go show up at a USCIS to get the fingerprints done, right? Judge says the application's abandoned. I said, the application's not abandoned. We're trying to get them done. It was absolutely just a miscommunication in its clearest form. And to me, that's what I say when I'm saying, you can't have form over substance. I mean, the disciplinary advisor basically laughed at me and said, "Why are you even filing this?"
Right?
Right?
They never even heard of it, probably.
Right? Well, they're like, why do you have to file this? This doesn't make any sense. And I'm like, I understand, but I don't know what else to do here because I have to comply with the Lozada requirements. And to me, that is such a tangible example of why a system that is put in place that is so rigid that it doesn't contemplate things like plain error, so it doesn't contemplate things like, simple mistakes, and it forces us into these kinds of paradigms. I think there's a huge problem.
I agree. I mean, it's clearly an elevation of form over substance, and it does make you, taking it back to what we were saying earlier, it does make you think that when they created this requirement, the board, they didn't really look at how this was handled in other areas of the law, or, I mean, it makes you wonder whether they looked or they didn't look. It doesn't sound like they looked closely enough at how it was handled in other areas of the law.
But they were using the same thing, though. That's the part that I don't understand. Is up until Lozada gets decided, they are running parallel on the Strickland standard. So there's clearly a shift. And again, it's before my time, so I can't say what was going on in the early 80s when, or the mid 80s when this decision came down. I don't know what the political climate was. I don't know what was happening, but clearly something shifts. And at that point, though, it gets so baked in that no one ever goes back to look at it again.
It was a little bit prior to, well, Ira's 90s, but this, I think, was like, there were, post-Reagan amnesty and leading up to some of the stricter immigration laws that came in with the Effective Death Penalty Act and certain other immigration laws that got kind of thrown in as amendments to that, leading up to Ira. So I think there was momentum toward getting stricter, but it makes you wonder, what was going on in the early 80s that put their head in this place. So prior to Lozada, like you said, they were under the Strickland standard, and they were handling ineffective assistance of counsel claims in the immigration court. They were doing it the same way as you would have done it in any other court.
Exactly. And they were judges were doing judgy things. They were looking at the record, and they were determining whether the facts showed that the attorney's conduct was deficient, and they were assessing prejudice. So they were doing the things, and then of course something shifts.
Yeah. All right. Let's talk about the movement to rescind the bar complaint requirement, which you are a big part of. So tell us about your efforts to spearhead the movement to rescind the bar complaint requirement.
So I'd say about 2 years ago now. I mean, this was something. So just so in full disclosure, I'm a prior assistant district attorney. So my roots were in the criminal world, right? And so that's kind of where I cut my teeth as a lawyer. That's where I learned my trial skills. Like that's where I learned. So to me, when I first shifted over to immigration, it was the same thing. I'm like, I don't understand what's happening here. Like this didn't make any sense to me on any level. And so I, for years, kept saying, this makes no sense. This makes no sense. This makes no sense. And I got to know a lot of the judges from the former roundtable, who were prior immigration judges. They've now become for the roundtable of former immigration judges. I think that's their the name of the organization. Anyways, and as we would speak, I would say, I don't understand this. And one of the people that I got to know was former chairman Paul Schmidt and former board member Lori Rosenberg. And these are all folks who are, legends in immigration law and were part of the dissenting voice when Lozada came through. And, one of the things I kept asking them is, why does this thing exist like this? And they said, we think that it's being used improperly. And that kind of fueled an already lit flame to say, we really need to undo this. And I will tell you, initially, it's funny when you tell people who are used to something that is abnormal as being normal, they don't always initially see it. And so more and more I kept saying, but look, folks, there's no other area of law that does this. And you can't tell me that you don't have bad lawyers in property law. You don't have bad lawyers as divorce lawyers. You don't have bad lawyers as, as criminal defense. Like, you have deficient conduct across the board, right? You may find people who do things in a deficient manner, but you're telling me that the only part of the legal process or legal discipline that is subjected to this is immigration lawyers. Why? And no one could answer that question for me. And slowly, I think they did go looking to see, wait a minute, we really are singled out as a profession. And so that's kind of where this effort took place. And as a result, I think there's been the voice and the efforts in the movement has gotten louder and louder as people really kind of started to say, yeah, this doesn't make any sense. And where you see how it's applied practically in the field, you go, yeah, this doesn't make any sense. And so, I was but one voice. There are now 1,500 more voices, other organizations that have joined in. And, I feel like the more people see it, the more they see why this needs to be changed in a really realistic way.
Okay, now how are people organizing to do this? You mentioned 1,500 other voices. I mean, how is the movement taking place?
Yeah, so what started is literally that a group of us that said we want to change this, and we started a petition that was designed to be sent to the administration to say, look, this is not fair. What's happening here? It's unjust. And that is now, like I say, there's about over 1,500 signatures from AILA attorneys who have, and that petition has been circulated to some of the members of the administration. Subsequently, the AILA Ethics Committee, well, let me back up. Through the work of the small group of us that started, we were able to get Professor Carla McCandles, who was with Vanderbilt University. And she said, you know what, I have an interest in this. And she put her students to work to do the deep dive into the jurisdictions and really create a document that we could use to build from. That document was turned over to the AILA Ethics Committee. The AILA Ethics Committee then did a full-on, full-throated review of Lozada in this requirement and came to the exact same conclusion that says, wait, we really are being singled out here, right? And so the AILA Ethics Committee then was able to put forth a recommendation that the Lozada, the bar complaint requirement in Lozada be rescinded in its whole and total. And then that has kind of grown from there. You now have AILA, who is putting forth a lot of efforts and a lot of energy to try and move the needle and really bring this issue to the forefront, which I think 17,000 members in this profession, we want to bring in more members. We certainly don't want people to not be a member. And I think that AILA has recognized that, yeah, this is something that membership cares about. So then they have put forth that effort. What then happened is that the AILA Law Journal did a piece on it. We authored a article for the AILA Law Journal. And then most recently, Senator Chris Murphy from Connecticut put forth legislation to say, I hear you. I think this doesn't make sense. And, we should put it in the statute, because really there's nothing in the statute even that requires a bar complaint be filed. And so we should statutorily make it on an even playing field and remove barriers to access to counsel, remove barriers to due process, and strengthen the immigration process.
You've talked about circulating the petition to members of the administration. I mean, it seems to me there are three routes you could go. First of all, if you're circulating to the administration, I mean, your ultimate audience would be the Attorney General, because he can snatch cases away from the BIA, make rulings that the BIA is bound to. So that it seems to me, and correct me if I'm wrong, that would be one. Number two, you're talking about Congress potentially enacting legislation that would fix it at the statutory level and have it sort of hard coded into the statute. That would be two. And secondly, the litigation route. I mean, going to the circuits or up to the Supreme Court, perhaps to resolve the issue. So, out of those three potential routes, I mean, how far are we? First of all, is litigation also being tried or contemplated? And on the legislative route, I mean, what advances have been made, or is it just something that's in committee right now?
No, I mean, I think, Senator Murphy has introduced legislation, so that is there. I don't know if it's gone to committee yet. I don't know. I know they've been on break and recess and whatnot, but they clearly have an interest in seeing this through. With regards to the Attorney General, I think Ayla has created a specific new petition, and we're encouraging people to sign. That is directed directly at both Secretary Mayorkas and to Attorney General Garland to say, look, you two should file or pass joint regulations because, like I said, this is an immigration law issue. This is not just a removal issue because we see it on the USCIS side as well. So I think there are some efforts on that end as well to try and put it in front of the administration. Yes, I agree with you. I think that Attorney General Garland could very easily and very quickly at least change course by taking Lozada or some other case on certification and kind of reassessing whether this framework still works 3.5 decades away from whatever was happening in the 80s. So that can happen. The other piece of this, you asked me about litigation. And here's the problem with litigation. I think we're a little bit stronger with Chevron deference gone, because I think now there can be arguments made to the court to say, look, it's not in the statute. It's not consistent with anything else. Reevaluate. But, if it was hard to get 3.5 decades worth of baking in, if you will, within the practice, cleansed out. I think about courts who have precedent after precedent after precedent of saying, we think the administration is absolutely reasonable in doing this. Boy, to try and now put that forth again and say, can you relook at this again? It's going to take a little time to get us there. There's so much water under that bridge that it is going to take a little bit of time, I think, to go up the proper channels. That doesn't mean those efforts are being abandoned. I just think that it's a longer road.
Which way do you think is the way it's ultimately going to get resolved? Can you tell? I
think we'll know more from the election.
Do you think it's a partisan issue or?
It's not a partisan issue, but unfortunately, immigration and the political climate are so tied together in the United States that I think it's going to be very difficult to say that it can completely be divorced from the political climate.
I could see the whole issue getting twisted into a pretzel and used in a soundbite somehow if the Attorney General decides to change it. I guess that's just, my worries about things because, that's happened with some other issues. But anyway, so it's too early to tell exactly, how we're going to win this battle. But you've got several irons in the fire in Congress, with the Department of Justice and DHS petition circulating, and then potentially the Chevron deference going, perhaps the litigation route as well. You may have said it, but has any litigation been started, or it's something which you think it needs to be contemplated, moving forward?
So that's the difficulty, right? I think that part of the problem is Lozada is still good law, and so we can alternatively make the arguments that say, well, we think that the record is clear, and therefore, we don't think that a bar complaint is necessary. But the problem becomes is one attorney is not going to file the bar complaint and now face a bar complaint because they didn't comport with the framework, right? It almost becomes that snowballing effect. That's why I say is that you're almost trapped in that box a little bit, because until Lozada is amended, you're stuck with the framework as it exists. So the only thing we can now do is kind of make the alternative arguments, but understand that really in those jurisdictions where maybe substantial or strict compliance is not there, that may be certain jurisdictions that are more fertile for some of these new arguments.
If changes are made and the bar complaint requirement is removed, how do you think that's going to impact the overall quality of legal representation in immigration?
I mean, I think that we're going to see people, you're going to see representation increase, not because of any other reason, but because people are not going to decline representing people in some of these that have some of these issues. I don't think any immigration attorney is afraid to stand up and say, look, judge, there was a problem here. We need to look at it again. And can we fix it? I think what they get weary of is this idea of having to turn on a fellow immigration attorney for the sake of meeting this mandatory requirement. I've declined representation. I said, I'm not going to do it. Because again, I know what it feels like to undergo this stress of having to file a bar complaint, because like I said, I did it to myself.
So is it something that you're publicizing heavily within AILA? Are there any other ways that you can think of that could get the word out? Maybe, if it's something that, how are people encountering, the petition and the movement? Is it something that's being circulated to all members, or have you made a video about the issue, or are you giving talks about the issue, giving sessions at conferences about the issue?
Yeah, all of those things are going on. We're also, the ABA has come forward and recognized that the bar complaint requirement is problematic, and it does serve as a barrier, and it is a problem. It impacts due process. So I think the ABA has come forward. The roundtable has come forward. So you are, like I said, you are seeing some of this now amplify with regards to various different entities coming forward and saying, look, we recognize this isn't working. I think all of us realize that if you eliminate the bar complaint requirement, whether you're on the government side or you're on the respondent side, you are going to build a better, stronger system, because you're going to open avenues to due process. And I've never met an attorney who says, God, I really don't like that whole due process thing. I've just never met that attorney. So I think, I do think that most of us want to see justice prevail. We want to see due process protected. And I think that by eliminating it, you start to see a system that is far more durable and a far more stronger system.
Now, do you think there's any value in having input from the state bar authorities? Any letters from them saying, like, we've reviewed, claims relating to, alleged misconduct or ineffective assistance, which, have we found, or we found meritless or not rising to the level? I mean, is there any input that you can get from state bar authorities?
100%. And that is an effort that is still continuing. I will tell you that there are some jurisdictions who will say, we treat every bar complaint filing exactly the same. It does not matter. There are some jurisdictions, especially in the non-strict compliance areas, where we've heard from disciplinary counsel and we say, you know what, when we see Lozada, we just kind of put it aside. Okay, well then now really why are we doing it? Right? If even the bar themselves says, it's one of those Lozada things, we won't really pay much attention to it. Well, then again, it is more form over substance, and that's what it's proving. So yeah, I mean, it's literally across the board. Those are the conversations that are happening to say, especially in those jurisdictions where the disciplinary advisor is, I don't know if they'll come forward and say, we'll just kind of throw it aside. I don't know that they'll feel comfortable to say that. But where those conversations are happening, there are people who say, look, we don't really pay much attention to it. The minute we see matter of Lozada, we set it aside because we know that you all have to do that.
Well, what are some actions that listeners can take? So someone who's listening to this and they want to support your movement, what can they do?
They can do a couple of things. Number one, and this is in particular with the petition, of course, we'd ask people to sign the petition. It's out on my LinkedIn. I can forward it to you all so that you can put it in the notes. But also, I think this is one of those times where if someone is not an immigration attorney, we need to hear from them, right? Because I think that attorneys from every discipline should be stepping forward to say, this is really not normal. And I think the more people hear that and the more other people from other disciplines come forward to say that, I think we really then start to show that this is an anomaly, this is not normal, and it should not be treated as it is normal. And so I think the work is work like you're doing, where you're helping to amplify the movement, you're helping to kind of get the message out. I think people should, if they have a vested an interest in this, then I think that is the best thing they can do is to kind of help amplify the efforts, because there's the old adage, right, that says the squeaky wheel gets the oil. And the question is how much squeaking can we make it before the administration says, yeah, this is really a problem.
Probably have to squeak pretty loudly.
Well, and that's going to require all of us then, right?
It is, and we will, and whatever links you send us so that people can access any materials that you've developed or sign the petition, get involved, send us those links and we'll post them along with the video. And Rekha, we've got a couple minutes left. So let me just ask you a couple questions so people can get a better idea about you and your profile. I mean, you mentioned that you came from criminal defense, or you came from being an assistant DA, you came from criminal law. How'd you then segue into immigration law? What keeps you passionate about this field?
It's a funny, I have always said the law picks you, you don't pick the law.
True.
And it's kind of how this happened is I thought I was going to be a career prosecutor. And when you are an immigrant yourself, what you find is everybody asks you immigration questions. And so I ended up kind of saying, I don't want to commit malpractice. So let me get some mentorship. And I mentored with somebody who said, look, here's what's going on. And in so doing, what I realized is they said, oh, well, you have a lot of trial experience. Do you want to handle our removal cases? And I said, absolutely. And then I spent my early years, I kid you not, getting thrown out of the INS office because I couldn't understand what they were doing. Like they would say things like, we're going to go talk to your client and then we'll be right with you. I didn't know what that meant. I was like, I don't understand. I am the lawyer. You're telling me you're going to go talk. Well, yes, but this is civil. And I literally spent the first 2 years of my practice just absolutely beside myself because I couldn't understand what they were doing. And I thought, this is crazy. This is not how this works. And then, of course, I started trying cases in removal proceedings, and they told me, well, there's no rules of evidence. And I said, what do you mean? And they said, there's no rules of procedure. I said, what do you mean? And then they said, by the way, you have the burden of proof. And I said, what do you mean? I'm not the government. And I literally spent that much, like the early years of my immigration practice, just being apoplectic and coming home and saying, do people know this is how this functions? And I think it ignited something in me to go, this doesn't make any sense to me. And so I'm going to go try and do what I can, because I feel like immigration court is trying a case with one hand tied behind your back and one leg tied to a tree. Like, this is just kind of how we are. And, I started really kind of bringing best practices to immigration court and trying to change the culture of immigration court to say, you're a judge. These are real rules. This is real life. This is a huge impact on this family. And I think I probably drove back then INS counsel crazy because I'd file motions and I was treating it like real court. And what that did is I think it moved the needle in a way to say, okay, we can use real tools that lawyers have to push the boundaries of immigration court to force people to play by the rules. And so this is kind of what ignited it. It's kind of kept me going all these years, but that's what I'm passionate about. And what I keep coming back to is that, these are real life decisions and that have profound impact. And I don't feel like we should just simply normalize how normal or lacking in, or how lacking in due process immigration court can sometimes come across. And I think as a zealous advocate, our job is to keep reminding both the government and the judge that due process is a constitutional right, and we have to, regardless of what anything else comes about, that justice prevails when justice is done.
Yeah, there's so many reforms that are needed. I mean, a couple of years ago, I interviewed former immigration judge, retired immigration judge Charles Honeyman, and we were talking about, whether immigration court should be an Article I independent court, and the consequences of it being an administrative court system within the DOJ. There's so many structural issues with it, and the consequences are so huge for the participants, for the respondents. It's certainly something. I mean, we'll definitely have you back, and we can talk more in another episode about some of these structural issues. I'm sure you'll have plenty to say about that. Also love to talk to you as we get closer to the election. I'm looking forward to, let's say, the Democratic Party coming out with its immigration platform and hearing in specifics, what they would like to do with the immigration system. And then hopefully we can have you come back and give some more commentary on the election and on the platform. But I definitely hope you'll join us for that as we get closer to November.
Of course, I appreciate the time. I appreciate you reaching out so that and helping us amplify this issue. I think it's very important. I think it is about strengthening the practice and really giving new attorneys an opportunity to do something that is more normal across disciplines than what has been taught generation after generation.
Yeah, I definitely agree with you on that point. Well, it's been great. And this is Rekha Sharma-Crawford, and she is the treasurer of AILA and a partner and co-founder at Sharma-Crawford Attorneys at Law. Rekha, thanks so much for your time, and I enjoyed it very much.
Thank you so much. I appreciate it.